matter of Seneca Meadows versus Town of Seneca Falls, and we are delighted to be joined by our colleague from the Appellate Division, First Department, the Honorable Martin Schulman.
May it please the Court, Bill Reynolds on behalf of Seneca Meadows. I would respectfully request to reserve 3 minutes for rebuttal.
3 minutes. Yep.
Thank you, Your Honor. Seneca Meadows is a landfill that has been operating in the town of Seneca Falls for decades. It is the largest landfill in the state by far, accepted nearly 2.2 million tons of municipal solid waste in 2018. I would quote the State Department of Environmental Conservation, which has described such facilities as critical to the proper management of waste generated in the state. Almost 1/4 of the municipal solid waste disposed of in the state in 2018 was disposed of.
What interest of the company is affected by, let's go with it for one moment, a violation of SECRA, as you have described the violation?
Your Honor, this law directly targets Seneca Meadows for closure, so the goal of the law is...
No, it just means you can't have any more landfills, right? You just can't have these waste disposal operations.
And that is what the company does.
I mean, January 1, someone else can't come in and open one.
It means that Seneca Meadows would have to
Well,
close.
you happen to have one, but it applies across the board. You're not unique in that way.
We are unique in the town of Seneca Falls, Your Honor. There is no other solid waste facility.
But you
in the
agree
town
what
of
they've
Seneca Falls.
decided is we don't want any of these kinds of waste management companies, right? We don't want this within our boundaries.
That is true, Your Honor. That is exactly the same as...
It could be you, it could be anybody else.
Well, except that in this case, there was no one else. There was no other facility discussed. There was no other facility in
And because of the way
existence.
they've written the law, no one will come after you.
That is true, Your Honor. But there was no other facility at the time that the local law was passed or considered.
Well, is it your position that they could never pass such a law?
Not that they could never pass it, but they have to comply with SECR to pass it, and they didn't remotely
Saying
comply
what
with
interest of your client is affected by not going through the SECR process? Because SECR is about environmental concerns, right?
That is
I mean, you may have other claims, and
Absolutely,
you
Your Honor.
asserted them and then stipulated them, right? You stipulated, withdrew them. So what's the environmental interest?
Well, as this court held in Har Enterprises and Gurnett Asphalt, when a property owner is directly targeted by government action, then the property owner, like Seneca Meadows,
Yes.
has standing to assert a claim under
Well, you are
SECR.
unique this way, right?
We're the only
You
one.
are unique this way, that your use of the property is raises environmental issues in itself, as opposed to just a property owner who just has property.
Yes, and again, Your Honor, we are the only...
I'm just saying, does that matter? Does it make a difference that the use of this property is one that, in and of itself, raises environmental concerns?
It does, Your Honor, because, first of all, because that's why the town board was required to comply with SECR in passing the law, which they didn't do.
So I'm saying, then passing a law that prohibits that use, how would that ever violate SECR?
Well,
Or, I'm sorry, how would that in any way suggest that there are environmental concerns that would be subject to a SECR analysis?
well, because there are huge environmental concerns implicated in this local law, because as I was
Did
mentioning...
you present those? Did you raise those as interests for your client?
We did, I'm sorry, Your Honor, did we or can we?
Did you? No, did you? We have the record that we have, so.
Yes. On the record, Your Honor, yes, it was raised and cited in our brief that Seneca Meadows did say to the board that if you close this facility, waste will likely have to be transported a longer distance, and that will increase greenhouse gas emissions, which has obviously...
If we were to agree with you on standing, why should we go ahead and reach the merits instead of sending it back to the appellate division?
Your Honor, I would suggest that the court should reach the merits...
Well, why? Usually we would allow the appellate division the first opportunity to consider a merits question, I think.
And this court, of course, can do either
Right.
one in its discretion.
But why are you suggesting that we should?
Because it's a pure question of law. The record was stipulated.
That's about our power, I think. But is there a reason why you think that would be particularly appropriate here?
Well, in this case, I mean, this litigation has been going on now for over 8 years. The local law is stayed by this court pending the outcome of this appeal, but is scheduled otherwise to go into effect at the beginning of January in just a matter of 6 weeks. If the court exercises its discretion to assess the seeker issue, which is a pure question of law, there's no factual findings involved, it's a stipulated factual record, then that would bring this litigation to a close. And I believe that the interveners also suggested that the same, that they would request.
So basically, some combination of efficiency and expediency.
Exactly, Your Honor, yes. Without trampling on any fact-finding or discretionary issues that would be reserved for a lower court.
Are you concerned in any way with the limitation defense issue at all?
Well, I would say, Your Honor, first of all, as we addressed in our briefing, first of all, the court can see that the board itself, the town board that passed this local law, is not here. They are not defending their law. They have not defended it for years. They don't argue that seeker was complied with. With respect to the limitations defense, Your Honor, that is a personal defense. It belongs to the board, not to the interveners. It belongs to a defendant or a respondent. We never sued the interveners. The interveners voluntarily chose to join the litigation. So the limitations defense is not properly raised by the interveners here. It would have been raised by the board, but they've abandoned that defense and any other defense because they're not litigating this case anymore before this court.
So therefore, there's no basis to bring up the August 2021 decision at all,
Yes,
as a non-final order?
well, yes, and we would also argue, yes, Your Honor, that it is also not reviewable by this court under CPLR 5501B and this court's Gilroy decision. The clear language of the statute and of that decision indicate that the earlier non-final order is not reviewable. So we would argue it's not reviewable, and even if it were reviewable by this court, the interveners can't raise it because it belongs to the board. It's a personal defense belonging to the board, not to the interveners. And again, I raised the points about the significance of Seneca Meadows, of the landfill, as a cornerstone of the state's environmental infrastructure. It performs a huge public service by disposing of so much waste in a state-of-the-art facility that is highly regulated, and closing such a facility, as the local law purports to do, raises serious and major environmental questions that affect the entire state. For example, I mean, to begin with, the facility doesn't generate the waste that it disposes of. The waste is generated by the state's economy, the state's citizens. The waste will continue to be generated next week, next year.
So then your position is they could never close this?
Not at all, Your
They
Honor.
could never close this, and they could never pass a similar law, even if they went through a secret process?
No, it would be, they could, Your Honor, but they would have to comply with seeker. They would have to
But
address the
it seems
concern.
that you're arguing the merits and arguing that the environmental impact would be completely negative, that is to say adverse, I should say adverse, if indeed they prohibited having this kind of facility on the property.
Well, I would personally argue that, yes, the overall environmental effects would be adverse if the facility were closed. It would be an environmental catastrophe for the state, in my opinion. But the important point for...
But you recognize that they might go through a secret process and reach a different conclusion.
Absolutely, Your Honor. The point is that they didn't.
So we don't need to reach that right now, do we?
The court certainly doesn't need to
Okay.
make a judgment about whether it would or would not be a good thing for the environment. The requirement of seeker is that the board had to do that. The board had to ask those questions and take a hard look at them.
Do you know if there's a plan in place if it's closed as of the end of the calendar year? I realize you may not know that, but perhaps you do.
To my knowledge, there's no plan in place.
Presumably, there would be a lot of waste to be disposed of, I take it.
Yes, Your Honor, and that's one of the reasons why we point out that it would be a calamity in terms of public policy, because to my knowledge, there is no public plan in place. There certainly is nothing in the record that the board has done or that the town has done to ascertain what would happen. I mean, when we talk about 2.2 million tons.
You had 9 years, didn't come up with a plan?
The board hasn't in 9 years. I don't believe so, Your Honor.
But if the law was in place, the business didn't think it might need a plan for how it would close down without an environmental catastrophe?
Oh, no, my client can close if necessary. My client's able to stop accepting waste, but it's not my client's responsibility to determine what will happen. That would
For the
implicate.
waste that's currently there?
Yes,
Is that what you mean?
we wouldn't be able to fix that problem. We would simply be forced to shut our doors. Then there would be hundreds of trucks.
Might you be in violation of federal or state law if you did not do anything with that waste and just left it there?
Well, it would be, I think what would happen is that on January 1st, 2026, the doors would be closed, and then we're talking about a process. The disposal of waste involves hundreds of companies.
I don't know the answer. I just don't know under federal and state law if you can just walk away and leave it there.
Well,
That's my point.
Well, there's a closure process that's environmentally required. If the landfill were to close permanently, there's a closure process that we would have to undertake at that point. But the issue about if the local law goes into effect, there are haulers all over the state that bring their waste to a facility, a landfill, to be disposed of. If the landfill's just closed, then there's hundreds of trailer trucks out there every day that have to find some other place to take their waste. And it doesn't appear from the New York State Solid Waste Management Plan that there's capacity in New York State to take the rest of that waste. And this just simply wasn't looked at for even 1 second by the board. I see that my time for this section has expired, so I'll reserve for rebuttal. Thank you.
Good afternoon, Robert Rossborough, Whiteman, Osterman, and Hanna on behalf of the respondents. Let me start with the timeliness issue that
Can
we
I
have
ask
here.
you, actually, on standing,
Yeah.
how you get around HAR?
We get around Har because what Har and Gernot did was acknowledge that under this court's two-part standing test, a landowner that is subject to the regulation gets a presumption that they will suffer environmental harm. That's what Har and Gernot both say. That owner is presumed to suffer harm as a result of the fact that their property is regulated. That presumption is not an irrebuttable one, however. This court has never held that
Point
it
us
is.
to examples where a property owner subject to a regulation lacks standing to challenge that?
I think in this instance, it
No,
would.
I mean in other cases where we have held, or maybe the federal courts have held, I realize different set of rules, that a property owner who is subject to a regulation lacks standing to challenge that regulation.
There are a number of situations where you have town-wide regulations, and the property owners cannot.
I'm just asking, sorry, I didn't mean to cut you off, but I'm just asking if there are any cases in particular that you could point us to where a court has concluded that, or particularly the Appellate Division or this court.
I can't remember names off the top of my head, but what I can tell you is sort of the principles. The principles are, in order to establish standing, the property owner has to show concrete harm different than the public at large. When you have a town-wide law that applies to everyone in the town, to have standing.
Is that true only if there are only one or two or three entities that may be subject to that, even if it's written on its face as a generally applicable law?
It is, because Har and Gernot didn't change this court's standing test. What they did is introduce the presumption that they will suffer
It
environmental
just seems, the reason I'm pressing you on it is it seems to me generally the case that property owners have the capacity to come into court and challenge a statute. Could be as arbitrary and capricious, could be with respect to secret, could be that it's a regulatory taking, something like that. And so it seems to me an unusual result to say a property owner can't do that.
I think generally that's correct. Generally, a property owner who is presumed to suffer environmental harm will have standing. What we have here is a unique situation where SMI has told the court in all of its allegations, its harm is economic. and economic alone. And that's what the appellate division majority held. It looked through the allegations of the petition, and the allegations of the petition are, we're concerned about the operations of our facility continuing to exist. The affirmation of Kyle Black does the same thing. We're concerned about our $10 million investment in our facility and all of the equipment that we have. And when a party comes into court and says, I have suffered concrete harm, and my harm is different, and the way it's different is that I have all these investments that I'm going to lose, that doesn't fall within the zone of interest for a secret claim. Now, it could certainly suffice for a substantive due process claim or a different type of claim, but for secret in particular, whether it's under Mobile Oil Corp. Or Dairy League Corporation, this court has held that you have to satisfy a zone within, an interest within the zone of interest. And SMI has said that they don't. Their interest is economic only. So we take them at their word. When their interest
So
is economic.
is your position they don't get what you've called the presumption that HAR recognized?
They
Or
initially
they're
did-
not targeted, or what is your position on that?
The presumption arises because they're subject to the regulation, but that's not an irrebuttable presumption. And here, their own allegations rebutted that presumption that they would suffer some environmental harm as a result of it.
I see. So you say they do fit under HAR because they're a property owner that would otherwise be affected, but they themselves have presented the effect as solely economic, which then takes it out of HAR.
Correct, and in
I
HAR,
don't see that in HAR.
well, in HAR, this court, in Gernot in particular, this court says we are not delimiting now what the sufficient nexus might be. And this is a case where you're going to need to further clarify what that sufficient nexus is. And wherever that line is drawn, I think, because the allegations here are solely economic harm, that does not fall within SECRA's zone of interest test under any decision that this court has ever held or any decision of the appellate division that I've found.
Are you aware of any cases in the appellate divisions or in this court where someone subject to SECRA because they're the property owner has been denied standing?
I'm not.
So we would be breaking new ground in that respect.
Well, in Mobile Oil, that property owner, this court held, would suffer only economic harm and was denied standing. They were part of the phased development of that
I
area.
really don't understand this presumption point when the language in both of those cases is, that the owner of property that is subject to rezoning need not allege the likelihood of environmental harm.
Right.
And you're saying here, he didn't allege the likelihood of environmental harm, he only alleged economic harm.
Well, what I'm saying is that the presumption arises because of who they are, but
But if
The
these
standing-
cases say you don't have to allege environmental harm, and your response to that is, but they didn't allege environmental harm.
my response is that in a case like this, that presumption to show standing is part of their claim.
Is there anything in those two cases that you see the language presumption?
There is.
Because I read it as, where the challenges to the secret review undertaken as part of a zoning enactment, the owner of property that is subject to rezoning need not allege the likelihood of environmental harm. So it seems in that case, what have you come forward with to say that it isn't?
And this is hard in the first paragraph. It says, we hold that whereas here the very subject of the proposed action is petitioner's property, petitioner is presumptively adversely affected
I'm sorry,
by the
where are you?
violation. This is matter of HAR
Yeah.
at page
And
526.
where do you see in HAR the notion that the presumption can be rebutted?
I don't see it in HAR.
Okay, so you're asking us to read into the word presumptively that you
Oh, I
could
see.
make a showing you're the property owner, but in what circumstances do you not have standing under your theory?
Under the what this court is asked to do in this case is clarify where that line is drawn, that
I'm
there's a
asking you what
sufficient
you,
nexus.
what you think, I take it you're arguing that HAR tells us that the property owner presumptively has standing, but presumptively means not always, and the presumption can be rebutted, yes?
Correct.
Okay, and what would be sufficient to rebut the presumption in your view? If we were to agree with you, one could read presumptively to simply be shorthand for saying property owner has standing without having to allege environmental harm. But if we read it as you're suggesting, what would be sufficient?
What would be sufficient is what we have here and what this court held in Mobile Oil. when the allegations of the petitioner itself, who is challenging the law, are solely economic harm. Not, we're concerned about, where the trucks might go or where the air emissions might be increased, because that was never alleged in this case. It wasn't alleged by it at all. What SMI has done now is tried to pull a 10-second statement.
So since Har seems to clarify that the interest doesn't necessarily have to be environmental for a property owner, and since you're suggesting that economic is not good enough, can I just ask you what's left? Can you speculate what a property owner might allege that's not environmental and that's not economic but might be viable?
I think what it would be is say, for example, in this case, DEC had granted a renewal permit beyond 2025, when this law would go into effect.
So they had like a regulatory.
They would have a regulatory interest in continuing under that permit. That would be sufficient to challenge the law. But we don't have that here. And if I might move, to the timeliness issue that I'd like to talk about a little bit. The issue we have here is in
But just, sorry, to hold you for 1 minute on
Sure.
Har. So Har says that an owner's interest may be so substantial, it's explaining why the owner might not need to show environmental harm, and says, for even though such an owner cannot presently demonstrate an adverse environmental effect, it has a legally cognizable interest in being assured that the decision makers have considered all of the potential consequences, taken the requisite hard look, and made the requisite reasoned elaboration. I just don't see there some notion that there's a rebuttable presumption and we should look at, I'm not sure what. I don't think, maybe, are you telling us that they must show environmental harm?
No, I'm saying.
What else?
So what I'm saying, and I think this is what the court held in Gernot, or at least my reading of Gernot is, in Gernot, you had a property owner who had applied for a permit to mine, and the town zoned, or said that's no longer a permissible use. As a result, that was this legally sufficient cognizable interest, because it wasn't just economic, it was interest in that regulatory approval that they were looking for that was a sufficient harm to
So
bring.
permit approval, environmental harm, anything else?
That's what I can think of.
Isn't that a pretty small universe? I mean, that would be a vanishingly small universe of eligible property owner challengers. I mean, yes, landfills need permitting, maybe mines need permitting, and some other kinds of business, but there's a lot of property owners who don't have to get permits to use their property. And you seem to be counting them all out of Har standing.
I think that
Can I ask, if they can't bring it, who could bring a secret challenge?
in this,
Different property owner that doesn't have a waste management business on their property? I mean, who would be able to bring it? Because Har is obviously concerned with the fact that then no one may be able to bring it. It does say, this is at the end of 529, to adopt the rule urged by respondent, which sounds somewhat like your rule, and deny standing absent an allegation that the owner will suffer some adverse environmental consequence, would insulate decisions such as this from judicial review, a result clearly contrary to the public interest. So who else would be able to make the secret challenge?
I think there may be some other property owner close to the property that would be able to bring a challenge to, on some environmental basis, for example.
There won't be as many trucks running by my house anymore?
That's at least an allegation of some environmental consequence. We have none here. Under
It wouldn't be a
SMI.
negative environmental
Yeah.
consequence,
Correct.
right?
But that's-
It seems not quite to be the public interest the court is concerned with.
Sure, and let me move.
That may be concerning, because if that's right, and the environmental consequence is perhaps positive because there are no trucks, I'm not sure we've identified someone who could bring a challenge. And usually, I think, with a major governmental action, someone who is affected, there's someone who can challenge that. So who here could challenge this if not the property owner?
I think there may be someone, but I'd like to spend a little bit more. I think, at this point, I feel like I've lost the panel, so I'm going to move on to something else, if I might.
Making the wrong assumption there, but okay.
So I think that if we deal with seeker, I think seeker is very straightforward here. This is the matter of Gernot situation. In Gernot, you had the same type of land use regulation. The board introduced it in July, 1 week later adopted an EAF, and a month later adopted the law after a public hearing and a negative declaration. This court specifically held that the rush to do that did not make it legally infirm. What we have here, in contrast, is a 7-month review where this law was introduced in May. It was supposed to be a public hearing in June. It was put off to July. It was then put off to September. We had 19 hours of testimony in front of the board.
To ask you a question that your adversary was asked, why shouldn't we let the lower courts sort this out first?
I think the answer is the record here is sufficient, and as a matter of judicial economy, it can be addressed now before the law goes into effect to give certainty to the parties. And if I might, in the last minute that I have, I don't think you have to reach any of this. This proceeding is untimely, and this court has the authority and scope of review
What
to
gives you
address
the
it.
authority, though, to bring that timeliness? As an intervener? Why isn't he
Well,
right that it's a personal right and you just don't
Number
have it?
one, the first time we heard anything about this being a personal right was on their reply brief in this court. It is an unpreserved argument. Number two, the reason why all of the other cases that they cite, the respondent was not allowed to bring a statute of limitations defense was because the municipality had specifically waived it. The municipality put in an answer that didn't raise statute of limitations or otherwise just address the merits. Here, the town fully litigated through to the appellate division the statute of limitations issue on their motion to dismiss. We did too. And as a party respondent, we have the equal full panoply of rights that a respondent has. And so because they fully litigated that issue all the way through to the appellate division and again raised it in their answer on the merits, now granted they decided for whatever reason no longer to spend money to litigate the case, but by raising it and fully litigating it as far as they could have, it is properly preserved and an issue here, and this court has the power to review it. If I might, I would just respectfully request that the court affirm, whether on the alternative ground that this case is untimely or we have satisfied the town board's obligation to comply with seeker.
Thank you.
Thank you.
Counsel, is he correct that, this is back to the standing, that your client took the position that it only had economic adverse consequences as a result of the alleged violation of secret?
It is correct that our client does not allege specific environmental harm, Your Honor. That is correct.
It never presented any potential environmental harm.
Well, I mean, I guess
But I
there's...
thought there was something in the record.
Yes, there are two pieces to that. Yes, we did say in one of the public hearings, which was not part of the seeker process, I would mention, because seeker was not begun until 10 p.m. on the last meeting with the lame duck board, when we were not actually able to participate in the seeker process. But we did say in just the public forums on the local law, we did specifically point out that greenhouse gas emissions would likely be increased if the landfill was closed because trucks would have to travel a larger, or may have to travel a larger distance. The town board did not even...
Emissions with respect to the town, in the town, or as a general matter?
As a general matter, which is what the board was not allowed to just look at the emissions within the town, but wherever they might reasonably be expected to fall. But again, I would just say, I mean, I think the court has a very good grasp of Haar and Garnett, but Haar explicitly said, we hold that whereas here, and this is on the first page of that opinion, the very subject of the proposed action is petitioner's property, petitioner is presumptively affected by the violation of secret requirements and that no such specific allegation is necessary, meaning allegation of specific environmental harm. This court couldn't have said it more clearly in Haar. Garnett is on all fours with this case in terms of standing because Garnett was a town-wide, as this court described it, was a town-wide ordinance, exactly the same. It removed a particular permitted use throughout the town. And as the court said, no one else would be able to challenge this law. I mean, the whole point that this court says in Har was to insulate decisions such as this from judicial review would be a result clearly contrary to the public interest, as was read earlier. On the limitations point, the municipality did argue it before, but they abandoned it. Statute of limitations is a personal defense. It can be waived and abandoned at any point in the proceeding. I'm not aware of any case that says it can't be abandoned at some point along the way, and it was abandoned. The board has abandoned the defense of the local law. It has abandoned any limitations defense that it may have. And if the court doesn't have any other questions, we'll rest on our brief.
Thank you.
Thank you.